racial disparities in the criminal justice system, and the death penalty and other extreme sentences has figured high in this regard. And I told the group in the minutes before you joined us that your resume, your CV was far too long to summarize here, and we would dispatch that, just noting that your position, your expertise spans both national and state concerns about the criminal justice system and the operation and the administration of the death penalty. I think perhaps the most important part of your biography is that you hail from Mecklenburg County.
Yep.
And if memory serves, you're a proud graduate of West Charlotte High School.
No,
oh, did I step wrong?
Second ward. My God.
Okay, well, I'm not sure where that memory came from. Yeah, I'm not a native of Charlotte. So
well, probably because Second Ward no longer exists, so it's been wiped from everybody's memory, except those of us who went there.
Okay. Well, proud graduate of Second Ward. I think I may have seen a memo or a memorial marker to Second Ward.
Yeah, right. Yeah.
But we're going to leave that history alone too. And we're welcoming you here to share with us some observations about the death penalty as it operates in North Carolina, and what we and how we should take on the responsibility of making recommendations to the task force and to the governor regarding how the death penalty should figure in North Carolina's future. Well, that's all the setup we've got for you.
Okay, well, that's good enough. Yeah. That's good enough. Okay, so first of all, thank you for inviting me to come and meet with you to talk about this. The death penalty is something that I have actually spent a lot of time working on, beginning in 1983 when I agreed to represent a person in Florida who was scheduled to be executed in 2 weeks. Through my time here at Duke, when at one time I had a death penalty clinic, and we worked with lawyers in North Carolina on death penalty cases. And then in the American Bar Association, where I was chair of the section on individual rights, it was called at the time. I was one of the principal drafters of the 1997 ABA resolution calling for a moratorium on the death penalty. I was the prime mover for a set of protocols that the ABA issued for states that were considering examination of their systems of capital punishment. And we thought that, rather than allow them to go out and, do whatever they thought was necessary to determine if their systems were flawed, that we should provide a set of protocols that would identify the issues that they should examine and how they should go about doing it. And so we did that. And they were issued in 2001 and then again in 2010. So I've had a good history with the death penalty. And let me just go straight to the bottom line of my view based on my experience dealing with capital punishment and death penalty cases. I think the death penalty is inherently discriminatory. I think its history is linked to the racism that taints our system and our society. I don't think it can be reformed. Ultimately, I think that anyone who examines the system closely will reach the same conclusion. I've told you about some of the things that I've done with the death penalty. Two sort of recent cases that I'm sure you all know about. When I was in private practice, I agreed to represent Henry McCollum. I was in DC, and I agreed to draft the MAR that was filed in his case. When I came to North Carolina, I wasn't a member of the North Carolina Bar, so I left the case with my firm in Washington, and they continued to work with Ken and others, and eventually, as you know, he was exonerated with DNA. And then here at Duke, I represented Charles Ray Finch, who was recently exonerated after spending 43 years in prison. The reason I bring that up is because he was sentenced in 1976 under the North Carolina mandatory death penalty statute. And not only that, he was the last person sentenced under that statute on the very day that the Supreme Court declared that a mandatory death penalty was unconstitutional in the Woodson case. He, although at the time that I was representing him on his claim of innocence, he was one of the longest serving person who had originally gone to prison as a result of a death sentence. The racial discrimination in the capital punishment system is historic. In his decision in the McCleskey case, Supreme Court Justice Powell suggested that the importance of history on the contemporary issue of racial discrimination is attenuated. That was only a hope in 1987, an aspiration perhaps, but not the reality. Since the Black Codes in 1866, in which North Carolina tried to nullify the 13th Amendment by severely limiting the rights of Black people generally, and especially their right to participate in the criminal justice system, except as defendants, there has been no point in time when the chains of discrimination and race have been completely removed from Black people. Rather than being attenuated, history confirms what our eyes see. There are people on North Carolina's death row now who were convicted by the same kind of all-white juries that could have heard the case in 1866, in 1946, the year I was born, in 1970, the year I graduated from college, in 1974, the year I graduated from law school. In fact, there has been no year when that would not have been true. The death penalty is a deeply flawed relic of that history. The only way to remove the history, the taint of its history, is to abolish its use. Much of the impact of race has reflected efforts by even well-meaning people to mask the racist history of capital punishment. Black people aren't trusted to be fair in capital cases because their experiences with race and discrimination that they would bring to capital jurors would make it more difficult for prosecutors to convict in many cases. Rather than eliminate the discrimination, some prosecutors take the easy road and eliminate the jurors who had the experiences. Death qualification of capital jurors has the same effect. People who oppose capital punishment for legitimate reasons based on their experiences in communities of color are removed from the system. In both cases, the effect is to lower the burden of proof in cases from which Black people have been removed as jurors. Rather than work to eliminate the underlying discrimination, prosecutors in New York, in North Carolina, probably in New York too, have been trained to remove Black jurors by using peremptory challenges. They've been offered excuses that would justify removing a person who was otherwise qualified to serve. And by doing this, what they do is simply mask the flaws in the system. There's no way to fix these problems. I have spent decades trying to get states to examine their systems of capital punishment to address systemic flaws. When I was active in the ABA, we raised money for this purpose. Some states refused to participate because they knew it was a fool's errand. The flaws are inherent. There's no such thing as a fair system of capital punishment given its history. If there were answers to the studies in Georgia and North Carolina showing the impact of race on the death penalty, the state of Georgia and the state of North Carolina would have produced studies to correct the damning pictures these studies painted. There are no such studies. Indeed, they have not even been undertaken. The North Carolina has, when it enacted the Racial Justice Act, it was following a path that Justice Powell suggested in the McCleskey case, in which he rejected the claim that the death penalty was biased based on the race of the victim, and said that to the extent that race tainted the system, that it was an issue or a matter that the legislature should address, not the courts. North Carolina, one of the two states that actually took up that approach, Kentucky being the other one, although I don't think that what they did was definitely not as significant as the Racial Justice Act, which North Carolina passed in 2009 and then repealed in 2013. What the legislature did in adopting that statute, I think, demonstrated remarkable leadership in dealing with the racial injustice reflected in the criminal justice system. It allowed individuals sentenced to death to challenge their sentence by showing that prosecutors had removed African Americans from serving on capital juries. It also allowed consideration of statewide evidence of discrimination at the time that the death penalty was imposed in individual cases as a basis of obtaining relief by individuals who had been sentenced to death. As you know, the legislature repealed the law, but not after most of the folks under a death sentence in North Carolina had filed claims. And as a result of them having filed claims before the act was repealed, the North Carolina Supreme Court recently allowed those claims to proceed. And I don't remember, there are 137, 138, something like that, claims that would have to be litigated and defended by the state if the state chose to do that, or as has been recommended, the other way to deal with it would be through the governor exercising his clemency authority. In 1990, when I was in private practice and active in the American Bar Association, I wrote to Justice Powell, who was chairing a commission to examine the federal habeas law and to make recommendations. It was supposed to be part of a deal. The states would agree to provide adequate counsel, and in exchange for that, the Congress would tighten up the federal habeas law, the thing that became the Anti-Terrorism and Effective Death Penalty Act, but it was supposed to have been a two-part deal, and they reneged on the part about counsel and simply, amended the habeas statute to make it extremely difficult to obtain relief in federal court once a person had been denied relief in state court. I wrote to Justice Powell because I've been involved in the ABA's effort, and I told him about my own experience, with capital cases, and I encouraged the committee not to eliminate federal habeas because, given the way that some states dealt with post-conviction cases, that the only chance that most capital defendants had in post-conviction cases would be in federal court. He wrote me back, and he said that his views were generally similar to my own, but that he didn't think that successive petitions were, well, he said that they were rarely successful and that they were a burden on the court. But what he said at the end of his letter was that, quote, "My own view is that the death penalty should be abolished." That is my view as well. Justice Powell spent a lot of time trying to rationalize the death penalty, trying to figure out how to eliminate the various flaws that got to the Supreme Court. When he left the bench, he told his biographer that the one decision that he regretted was his decision in McCluskey. I don't think spending a lot of time studying the death penalty will tell us anything that we don't already know. But I do think that it is really important if we are going to deal with race and racial discrimination in the criminal justice system to deal with the death penalty, because not only is it important substantively, although increasingly it's not a punishment that jurors are imposing, it does have a great symbolic importance. And I think that the symbol is wrong in every respect. So I encouraged the task force to recommend whatever is necessary to educate the public about the death penalty and how it is administered, to encourage the branches of government that have the authority to take action to correct some of the consequences of the flawed system in the past. I believe, as Justice Marshall said in his Furman decision, that if the public understood how the death penalty was administered, it would reject it as a punishment. I think we actually are moving in that direction. I think the public is beginning to understand how the system works. But I think that it's important for your group and for the task force to do whatever it can to accelerate the public's education on this issue. I heard an expression that I had not heard before a couple of days ago, and it was to that what this task force can do is to provide, and the phrase is the aspirational thrust necessary to educate the public and state officials to face the reality of capital punishment. I hope that that is what comes out of your recommendations. I think that it would advance the cause of racial justice in the state if at some point in the future we don't have to deal with the death penalty.
I have a copy of that letter.
Oh yeah, so I sent Mercedes a copy of my letter just so you knew I wasn't lying.
I kind of formatted it here, but it's there, and it's powerful in the way that he put it there at the end.
So I correctly quoted his letter.
Yeah.
And this was sent in 1990, so almost exactly what
30 years.
30 years ago, almost exactly to the day. So there you go.
Judge Clark, I know you've got court. Judge Locklear Clark, I know you've got court in moments. So if there's any question or comment you wanted to make before you left, this is the opportunity to do it. Professor Coleman, it strikes me that your experience with, I've often commented that my legal career, starting law school in 1977, just as the death penalty was being restored to our system, has tracked the 40 plus years of the death penalty. It seems like your career as a much wiser and older member of the bar has an even longer overlay.
It does. I have a very long pedigree with the death penalty. So, I've made efforts to try to reform it. I've made efforts to try to get people to examine it, and identify flaws in it. And what I've concluded is that the people who are responsible for the system and who know it best know that it can't be reformed. And it's like building this contraption that's at the top of our criminal justice system that, every now and then somebody goes in and adds a new floor or, put in a new piling or something like that. But, I think that ultimately what we ought to do is just remove it from the system.
And I think it was 2015, the case of Glossop versus Gross was decided, and Justice Breyer wrote a very widely circulated and read dissent from that opinion. And in that dissent, he sort of surveyed the 40-year experience with the modern death penalty. And just the extreme nature of, first of all, the research and study and consideration of the death penalty, which amounted to various tweaks of the machinery.
Right.
And Justice Bryan, Justice Ginsburg, all but threw in the towel on it, but invited some of what this task force is doing, and that is to, they invited briefing. Hoped that the Supreme Court would take briefing on the very many constitutional challenges and practical challenges that the system presents. I don't know if you've had a chance to look at the proposals that
I did
in draft form.
Yep, I did. And I would support all of them. I mean, as I said, I think that further study of the death penalty is not likely to produce anything that hasn't already been considered. But if it helps to educate the public and if it helps to educate state officials, then I'm in favor of that too. I think anything that we can do to get people to candidly discuss the death penalty and to examine it with integrity, honestly. I think I have no doubt that they will reach the conclusion that I reached, that others have reached. I think that that Justice Powell expressed in his letter that we're better off without the death penalty.
I don't know if you've, Mercedes, that we haven't really sort of played through the most efficient way to go through this draft list, but it occurs to me as we go through the recommendations, the first one having to do with the funding of a conviction integrity unit within IDS. You know, one thing that we didn't say is that you're the director of the criminal justice, and I'm sure I'll get it wrong, center at Duke, which is both a wrongful conviction clinic and an innocence.
Yep.
And one of the issues, one of the problems with what you do is that this is an academic, a university setting, you're using students, you're hoping to accomplish things, but you know, for the most part, there are people and stories out there that don't get told.
Right. Exactly.
I remember the first case I had as a lawyer in North Carolina was that of Anson Avery Maynard, a man who was convicted and sentenced to death out of Harnett County. And it was clear that all the physical evidence tied to a white man who barely remained a co-defendant for a matter of months. Anson was Native American, he was Lumbee, no physical evidence attached to him. It was really the word of this co-defendant. Co-defendant was not prosecuted, Anson was sentenced to death. And it was only through the clemency process that Governor Martin, a Republican at that time, convened his group of advisors, a trial essentially, and was convinced that Anson was innocent. And the response to innocence back then, and this was 1991, was converting that sentence to life without parole. Right. So an innocent man died in prison, right. Because that was the state of affairs in North Carolina in 1991. So this first recommendation, part of the first recommendation is, well, the state, we should have some responsibility for having the capacity to investigate and litigate on behalf of people with significant claims of innocence.
I agree strongly with that. We do what we can in the law school, but we don't have subpoena authority. So we depend on people cooperating with us. And even with that limitation, I think we've been successful. But I think that it would be significantly better if there were such a unit set up by the state of North Carolina to look into these cases. I mean, we would continue to do what we do, but I think having a partner in the state would make all the difference in the world. When we do these cases, we don't try to hide the ball from anybody. What we always do is to write up our case, give it to the prosecutor, and ask him or her to review it, and if they agree, then what we would prefer is that we can convince them to join us in seeking relief, and we were able to do that in a number of our cases. But I think it would greatly improve the system if there was such a unit established.
It might be worth it. So one of the outcomes that we want for this meeting is to see if we can come to a consensus. And I know we don't have Judge Thornburg on, but we do have the rest of the members on, I guess 5 out of 6. And so I'm wondering if Henderson, maybe you wanted to call to see if there was consensus on these 2 recommendations related to claims of innocence and then investigations, like, conviction integrity units.
I think that makes sense. So why don't we call that question and get sort of a general thumbs up or assent, or first of all, is there a general sense of consensus as to these 2 issues?
Oh, 4 or 5.
I support both of them. I think, with both of them, as with everything, the devil is in the details. So, we have a post-conviction statute. We have a lot of entities right now doing post-conviction litigation, and it's really time consuming, and there are some constraints with the MAR statute. So I would hope that a conviction integrity unit would have a statutory charge that would allow these claims to be expedited. And it's not just the death penalty. I'm thinking of a case my office handled a few years ago for a man who was wrongfully convicted of 4 counts of forgery and uttering, and sentenced to 12 years because he was a habitual felon, and he had to serve 4 years before he could get relief because we couldn't get traction on his MAR. So again, the devil's in the details with both of these recommendations, but I support both of them.
Very good.
All right, moving on to the next ones. These are specific limitations on, well, the first has to do with commuting the sentences of the specific individuals that Ken Rose had spoke about last meeting, and then specific prohibitions on classes of individuals. And Henderson, I will defer it back to you to talk about.
Jim, I think you're generally aware of the 2001 divide, such that the cases that were tried and went and sentenced before 2001 were really an extension of the North Carolina's mandatory use of the death penalty. And we had a very strong recommendation or presentation from Ken Rose. And out of that presentation is this recommendation that those pre-2001 cases be given special consideration by the governor for the exercise of executive clemency. Do you have a view on that?
Yeah, I do. I mean, I agree with that. I think that that the line that divides the call it the modern statute from what came before it addressed a lot of the issues that the American Bar Association had raised with how the death penalty was being administered. And as Ken argued, there was almost a mandatory a requirement that prosecutors seek the death penalty. And in a lot of the cases, that resulted in a capital sentence based on facts that I think most prosecutors would say likely did not warrant the death penalty. And it seems to me that this is one of the things that the governor could do without any legislation, could review these cases. And I think that it would be an appropriate response to what we've recognized now as being a better approach and allowing prosecutors to have the full discretion that they would otherwise have in non-capital cases on what punishment to seek.
Okay. The other part of this slate addresses persons with serious mental illness and those who are under the age of 21 or under. With respect to the age, the Supreme Court addressed 18 as a cutoff. Since then, there's been huge litigation around that cutoff. The science teaches that the brain continues to develop until age 25. In fact, 26 for males. Apparently females develop at a faster clip. And so this recommendation, I think we should actually have a debate over whether 21 or 25 is the appropriate cutoff. But do you have an opinion as to either or both of the serious mental illness and the age cutoff, that recommendation?
I also agree with both of those recommendations. I represented with Jay Ferguson, represented Guy Legrand, who is, he's still on death row, I believe, although the court found that he was too mentally ill to be executed. I mean, it's the first case I ever testified in, because I had an experience. I visited him at Central Prison to talk about his case. And he just had an episode. So we shouldn't have people like that on death row. It just it's below the dignity of the country, of the state. I think the people in the state, to put somebody like that on death row. So I absolutely support that. And the same thing. I mean, I think that one of the things that happens is that we learn. Every day we learn more and more about the development of young people, and the extent to which they're able to control, their impulses, and therefore the extent to which they are fully blameworthy for some of the criminal activity for which they're responsible. So I would also agree with you that whether it ought to be 21 or 25, I think if you're going to do this, then you ought to figure out what the right age is, and not try to do it in increments of 21 now, 23 later. Let's just sort of figure out what the best age is to make sure that we've protected the most people that we are able to protect.
Mercedes, I think that's a very good point. I think what I'd like to do and get your help on is to put in the Sharepoint some of the scientific development since Roper versus Simmons, which I think pretty persuasively demonstrates that age 25/26 is the appropriate time. And if we could sort of find that in time to inform the straw poll, I think that would be good. I might have a lead or two.
So what I'm hearing is that you want to amend the language here to read 25 or younger at the time?
I think that's, if we can find that support for it and put that in the Sharepoint so that there's a record.
Of course.
This is not just sort of willy-nilly.
Sure.
That this is where the balance of the scientific evidence lies. I think that would be helpful.
Okay, I will do that. And so I misspoke earlier. I was counting myself in the little tiles here. There's obviously only 5 of you guys, and now we are down to 3 of the 5 of us. So I'm thinking, because we want to make this change, you tell me, Henderson, how do you want to handle with
Well, I think we should note the reason for the recommended change. Again, try to put that in the Sharepoint and have that, make that clear in the straw poll that we circulate. I think we probably don't have a quorum.
Right.
With our current group. Both of our judges are gone.
So I think it might be best if I send out a survey after the meeting to just up or down vote on all of these. But we can keep going just to discuss and make sure we have a chance to discuss, obviously. So this was the next one about the 14-year cessation of executions. So make sure I make that one change, 25, and then get the supporting document. And then, so if you want to talk about this one.
Professor Coleman, I believe right now there are 4 states with formal declarations of moratoriums against executions. I recall that in North Carolina, there have been movements for a moratorium since at least 2000. I recall Mecklenburg City Council, it carried, I believe, in 2001, but there have been movements across the state since 2000. We have, in fact, had a de facto moratorium since 2006, 14 years. The recommendation here is to formally announce what has been the state of affairs on the ground, a moratorium against executions, but to link that formal announcement to work, the actual work that would have to be done to inform the public about the appropriateness of continuing the system the way it is. And so what this recommendation is doing is suggesting a formal announcement of a moratorium and the convening of a blue ribbon commission to examine several charges, several aspects, leading with the issue of racial disparities in capital punishment, the prominence of wrongful convictions, and we saw evidence that of the 9 or the 10 capital exonerations, 9 of them were persons of color. So across the board, this issue of racial disparities should be the first subject of investigation or review. A colleague of yours, Phil Cook, did a nationally respected study of the cost of the death penalty in the early, I believe it was about 2001, 2002.
Yep.
And that study was updated in 2009. And again, the methodology is one that's been adapted across the country. The question is, that should be a matter that the commission undertakes. And I think with upwards of 100 cases going back to evidentiary hearings because of the Racial Justice Act, there's a real question. Should that investment be made, or is there a better use of public safety dollars? The third bullet, we had some presentation, or actually Working Group 3 had an incredibly insightful presentation from Danielle Sored about the need to look more broadly at harmed parties and how, as a society, we respond to the effects of violent crime on individuals, families, and communities, and that more needs to be done in terms of advancing public safety and harm reduction and restoration. We've had contributions from the public. I personally have been in contact with 2 witnesses who responded to these efforts, both of them identifying the big fault in the system is that there's no way to get to honest redemption, honest expressions of remorse, and that victims want primarily first safety for themselves and their family and safety for the community. And they see expressions of remorse and redemption as part of that. And our system really doesn't provide for that. The counsel issue that you've had long experience with, and then what many states have done is simply redefined the maximum punishment for murder to being life in prison. So those are what we would extend or suggest specify to the study commission for review. How do you regard those recommendations? Are there anything that you would add or subtract?
No, I would not add or subtract anything. Let me just say that this is exactly what we started to do in around 2000. I mentioned that when I was chair of the ABA section of individual rights, I had the section produce a set of protocols. We call them the protocols on the administration of capital punishment. And you know, you can't see this, but I'll send it to Mercedes, but it was intended to be a guide for examining a system of capital punishment. It didn't include the third bullet because that's not something that has been discussed. At least had not been discussed at the time, but it did include the other bullets. And you know, we had experts from all over the country review this, including Tony Amsterdam, and you know, so it's available to look at. 12. We had 12 what we call preliminary assessments done in 12 states with full reports. They're on the ABA's website. So, you know, there's a lot of work that's been done on this. And so you wouldn't have to, sort of reinvent the wheel if the task force decided to make this recommendation. There's a lot of material to start with that allows the state to tailor, what the study would look like. But I think what would be different about this for North Carolina is that it would be a study done by the government as opposed to done by groups within the state. Which is why we called it a preliminary review. The idea was to show what deficiencies there were based on a fairly quick but thorough examination of some of these areas, and then present it to the state to decide whether they would conduct a more formal review. None of them did. But I think it would be, and I also think it would be part of the education process if the state undertook something like this.
Thank you. I'll just say another point about bullet number 3, and that is the role of harmed parties is one that is little discussed, but one that, in 30 years of work at the trial and post-conviction level, I've sat in many a living room with surviving family members, and surviving family members and victims are not monolithic.
Right.
And what they want out of the system is different. And the question is, do we have a system that allows for people along that spectrum to get something that moves them and their families and communities closer to healing? And I think a commission that spends energy and time surveying that stakeholder group would have much to inform.
I was on a panel with Sister Helen Prajian down at William and Mary, talking about, she was talking about her experience with capital punishment. I was talking about some of the stuff that I'd done. And she said at dinner, she said that the one thing that she regretted more than anything else was that she didn't reach out to the families of the victims, because she thought that they wouldn't want to hear from her. And that the one time that she did, and it's in her book where she reaches out, she says it was just an extraordinary experience, both for the family member and for her. And that's something now that she does, as a regular matter, that for exactly the reason that you said, is that, these families have different needs and different approaches to people who are doing the kind of work that she's doing.
Mercedes, what's the next slide?
Mercedes, you're muted. Oh, did we lose her again?
I think so. I think
it looks like it.
There are just a couple more. Let me see if I can.
Yeah, I'm looking as well, Henderson.
Henderson, this is Mike. While she's looking that up, could I ask a couple of questions of Professor Coleman?
Oh, please.
Yes.
First, thank you. I'm a member of the task group. I'm not an attorney, and so I kind of play the role of the average person here on this group. And I want to go back to something you said way back at the very beginning of your comments, when you said that it's your view that capital punishment is inherently discriminatory, and that it is beyond modification, that we really just need to get rid of it. I think it's such a, again, speaking just as somebody who owns a restaurant, it's such a emotional issue for so many people that in order to win hearts and minds on it, we need to kind of be able to distill it down to an understandable, brief talking point without, and I don't mean that in
No,
a trivial way, but,
Yeah.
and if so, what would that be?
Well, I don't. First of all, I agree with you. You know, I have always in the work that I've done, both death penalty and wrongful convictions, I've always made an effort to talk to everybody involved in the case, anybody who has a view on the case, because I think that's the way we ought to do it. We should not be hiding cards from people. We should tell them how it actually works. We should understand what it is about the death penalty that they think is important to them, and address that. I mean, I think you couldn't abolish it without doing that. You've got to hear people on all sides of the issue, and I would do that. So if you were going to do a study commission, that's one of the things that it could do. I was on the Chief Justice's commission that made the proposal to raise the age for juveniles, and that's what we did. We had a series of hearings around the state and listened to people who supported raising the age. They came and they told their stories. And, by the time it was all over, it wasn't controversial on the commission. And we had a very, diverse group of members who, from different backgrounds, different views on a lot of the issues that we were talking about. But we were able to build a consensus by doing that. And I think a consensus can be built on the death penalty too, both in terms of the cost, because, the number of cases are dwindling in terms of even the cases in which people are seeking the death penalty. And the question is, do we continue to spend the kind of money that we're spending to try to execute, 2 or 3 people? And then we've got all of the people who are on death row now. And the question is, are we really going to, go through a process of litigating each one of those cases, in order to try to execute the person? So, I agree with you. I mean, I think the instinct is correct. We ought to talk about this. We ought to talk honestly about it. And then, at the end of the day, see how we come out. I think that's the way to do it.
Yeah, Mike, the only thing I would say to you is I've never been able to predict what the one issue is that is compelling to a person without engaging them.
Yep.
Because until you have that conversation, you don't know if it's the cost issue.
Right.
We only have X dollars of public safety dollars, and it'd be better to close some of these cold cases than to spend over $1 million more to seek an execution. Whether that's the issue, or whether whether it's the story of Henry McCollum and Leon Brown, who spent 30 years wrongfully convicted,
right,
and what the risk factor is for an innocent person, and how that risk factor increases if the person is intellectually disabled or close to that, or if there's some other serious mental illness operating there. And my goodness, if it's a person of color. So, but until you engage the person, you don't know which of these issues is going to be more compelling. Sometimes it's the issue of redemption. Some of the people, and I'm thinking about the last client I had that was executed, Elias Sirianni. No doubt that he was guilty of the crime. But by the time we got around to killing him 14 years later, everyone from the domestic violence officers and task force and local prosecutor, they all agreed clemency was the right outcome. Governor Easley was the only one who disagreed. And so he was executed. And I think most people continue to think of that as a real tragedy, if that story is told. So I think it's which one of these things is compelling. And that's why this recommendation that the commission hit at least these bullets because they guide the conversation that we need for this public education project.
I'll tell you a quick story. When we were doing the ABA's moratorium resolution, we originally we were going to do it at the summer meeting of the ABA, but we decided not to do it then because because we thought that Bill Clinton would come out against it. So we waited until the winter meeting that next year in February, and in the meantime, we decided that why don't we go out and see if we can get former presidents of the American Bar Association to endorse this, and that's what we did. And every single one of them, every single one endorsed the resolution. The only one who didn't was the one we didn't ask, and that was Justice Powell, because he had just stepped down from the court. But every living former president of the ABA endorsed the resolution. And, when it finally got to the floor of the House of Delegates, it was overwhelmingly passed, and that's not something we would have predicted.
You didn't have that letter at the time?
No, I didn't. I've never used, I did have the letter, but I've never used it. I've never disclosed it. But he's talked about his view on the death penalty, so I don't think and he didn't tell me it was a secret.
Mercedes, I'm not sure where we are. I know because of the quorum issue, I'm thinking that it's helpful to go through this discussion, and that the next points issues may just be something we have to follow up with online.
So they're ultimately, these are the last two recommendations related to what we were talking about. And I do think that the next steps are going to be to do a survey, a very quick survey of the working group that I hope to get out by the end of the day. And with y'all's having a response by Thursday mid-afternoon, or excuse me, mid-morning, the afternoon being a deadline, so that we can get it out to a task force straw poll on Thursday. Good.
And so on this last two recommendations, one is a recommendation about the MAR statute 15A 1419 B2. And Jim, you'll recall this is the procedural bar discussion.
Mm-hmm. Yeah.
What we're suggesting is that we add a provision there in the interest of justice, or where the petition raises a significant claim of race discrimination.
Yep.
And I'm recalling the argument in the RJA argument where the court asked a couple of times, couldn't we resolve this just by the government waiving
right
procedural default? And the question was whether that person was authorized to do that.
Yeah.
But this is sort of we've got a system of justice. Should procedural bars prevent something as significant
right
as claims of racial discrimination? So that's the fix that we're suggesting the study commission review. And then there's a notion of whether the RJA canon should be extended to life without parole cases, and how that would work, how we compare the experiences that California, who is going down this path, is something that the study commission should look at. Do you have a view on those two recommendations?
Yeah, on the first one, I participated in the clemency presentation to Governor Easley in the Robert Bacon case. And that is a case where, we had a claim, a significant claim of racial discrimination during the jury deliberation. And based on that, he commuted his sentence from death to life. And I think that, that is that ought to be a way for a court to reach a legitimate, a non-frivolous claim where there is evidence that race tainted the case in some way. So I would absolutely support that. And then on the other one, Brandon Garrett just did a study here that they released at the end of October about life without parole cases, and and his study shows some of the same sort of race impact in those cases that they found in the death penalty cases. So, what happened is that in counties where the majority or a significant majority of the victims were white, you have a much higher percentage of people who get life without parole. So I think that's something to study and see what the facts are.
Mike, on the first provision, the procedural bar, that refers to what most people would regard as a technicality in the law. So that if at trial a lawyer failed to object to something that was wrong at trial, if you failed to object and you had an opportunity to object, when you come to the Court of Appeals or to the Supreme Court, they look at the transcript. You had the opportunity to object, you didn't object, that claim is waived. There's a procedural bar to that court hearing the claim. If there's a claim that's discovered in appeal, or that could be discovered in appeal or in post-appeal investigation, and you don't raise it, the lawyer fails to discover it, fails to raise it, well, then when you appear in court at the motion for appropriate relief, the MAR court, that court will look at the record and say, well, you had an opportunity to raise it here, you didn't, it's barred by this procedural bar. And so that technicality can stop the pursuit of justice because that door is closed, because the lawyer failed to raise it. So in part, that goes back to our recommendation earlier about the quality of counsel, so that you have a better grade of counsel, so the risk of not raising those issues are lower. Right. But even with good counsel, it can happen. And the question is, if that failure happens, must the system just throw up its hands, or can or should a judge be permitted to get, in the interest of justice, deal with that kind of claim? So
yeah, thank you. I want to say, Henderson, while you were explaining that, I was thinking, I look forward to taking the LSATs after I complete this.
Well, I think 3 months of apprenticeship, Mike, we can waive that LSAT thing. You're ready to go.
This, by the way, Henderson, is the issue that I was discussing with Justice Powell in my letter. I mean, the letter that I wrote to him was about, procedural bars, in cases where there was a non-frivolous constitutional claim, but the lawyer had failed to raise it in an earlier petition or something like that. And before they amended the habeas law, basically federal judges could, if they found it was in the interest of justice, without showing that the person was actually innocent, they could hear the case. And then, they eliminated that. I think that, this is if you're concerned about the impact that race has on the criminal justice system, allowing a court to review a legitimate, non-frivolous claim in a case where you show that there's been some, significant reason to think that race was a factor, it seems to me to be fair and restores some of the balance that was taken away, I think, after, the effort to try to keep lawyers out of court in these cases.
Well, thank you, Professor Coleman. I think you've been very helpful in this conversation. We're hoping that there's an invitation extended to the other working groups, and we hope that some of our other task force members will have been able to monitor this. And also the conversation is recorded. So we will be able to replay, folks will be able to replay this discussion, at their convenience. But I must say it's been very helpful and instructive. quite the class. Thank you.
Okay, well, it's good to see you all. Good to meet you, Mr. Hawkins.
Mercedes, is there anything else that we should say before signing off here?
Very, very quickly, just summing up that our fines and fees recommendations did all pass through the task force this last week. So congratulations to y'all. Minus that administrative driving while license revoked
is being lumped into a different task, different working group recommendation.
And Mercedes,
Yes.
I'm sorry to interrupt. I wanted to also let you all know, Mary, I think, had raised the fact that you all had dealt with failure to appear, and the working group 3 had dealt with failure to appear in working group 3. And so I just wanted to let you all know that we have resolved those. We don't believe they're in conflict at the staff level, and the co-chairs have agreed to a resolution that we're going to send out to the task force for approval. But basically, we're going to take what y'all said and what they said and put it together because they don't seem to be in conflict.
So currently, right now with the task force on straw poll is prison discipline and redressing sentences and the collateral consequences. And actually, there's an error right there. Collateral
Consequences and prison discipline and redressing sentences are all going to be going for a final vote this Thursday, the 13th, with our reentry programs and hopefully our death penalty recommendations going for the vote on the 18th. And Jasmine, if you can go to that last slide, I believe our next steps are, before this is the second to last slide, we, as a result of that survey last week, a lot of the feedback with respect to the felony murder recommendation is that we have not had time to discuss it clearly. And some background discussions here are that what we're thinking is the data on felony murder is not available. We can't find that on a race-based level. We checked with the Sentencing Commission and they don't have that. It's not available to be presented. And so the recommendation, and I'll put it out in the survey that's going to be coming out after this meeting, is probably going to be something along the lines of the study commission. And Mary, maybe if you want to talk real quick about that, 2 minutes.
No, I just wanted to say it's Friday the 13th, right? It's not Thursday the 12th. I think your slide said Thursday the 13th, and I was starting to lose my.
It's Friday. It's Friday the 13th, Mary.
Okay.
Sorry.
Okay. No, we had touched real briefly on felony murder, I think at the beginning, maybe before we were all online. But yeah, I think in light of the lack of data and the lack of kind of alternatives we can put forward at this time, we would fold this into a study commission going forward, along with the other, studying habitual felon and some of the other things we've discussed.
Okay.
Yeah.
Do that one. Okay. And I think next slide should be the last slide. And I will ultimately be following up because it appears to be necessary.
Okay.
The survey, and I will be asking you guys to respond no later than noon on Thursday. If you can just get on that as soon as possible. And then, our next task force meeting is Friday,
November the 13th. And then the last task force meeting is Wednesday, November the 18th.
Okay. And it's at that meeting you're providing snacks, or?
That'd be awesome, wouldn't it? Yeah, no.
No?
But maybe you could.
We'll take that under consideration.
Okay.
Well, thank you. A lot of work ahead of us still. But this will have been our last working group meeting, right?
It is.
Oh,
it is.
Well, Mary, you should have provided snacks for today.
Oh, well. I'm going to go downstairs and find one as soon as we're done.
Me too.
I was going to say, that was why I turned my video off. I was kind of eating some along the way. Halloween candy.
I think I heard Mr. Hawkins say he's a restaurant owner, so I think as soon as we can do so safely, we should all drive west and join him for a meal.
Head for the hills.
You are all welcome, believe me.
I'll be sure to check it out next time I'm out in the parts.
Okay. Good to see you.
Thank you all.
Thank you.